I was going to call actually Larry Jefferson from the Washington Association of Criminal Defense Lawyers and the Washington Defender Association, and Sinead Brown with the Racial Equity Team, Blackout Washington, and Ending the Prison Industrial Complex, EPIC of Seattle. You guys are on it. Thanks. So, whichever order you prefer.
Yes, I think I've been deferred to, which is a pleasure. Thank you. My name is Sinead Brown, for the record. I am a part of Ending the Prison Industrial Complex, the Racial Equity Team, Blackout Washington, advocacy for families of African descent here in Washington State. And I also want to express appreciation that we're having this conversation about criminal justice and race, not as two different conversations, but as an understanding that our criminal justice system is heavily steeped in racism. I do racial equity trainings as a part for a living, and I work with a lot of institutions about how do we acknowledge the harm that has been caused by our different systems that is very racialized, and how do we begin to look at strategies to undo that. And then also in my community capacity, the understanding is that communities of color that have been harmed, not just by the criminal justice system, but by the compounded consequences of each of our systems, how do we step up into the leadership that's needed to create solutions to move forward in our state? So that's one of the things that I want to talk about. I'm sure that you guys have heard plenty of testimony. We've all read the new Jim Crow. We understand the racialized nature of our criminal justice system. I think where we get lost is when we get to the strategies. Community-led alternatives, I just came from Policy Link, a summit in Los Angeles, and there was someone there from the White House who was talking about community-led alternatives is a new pilot program that they're rolling out. How do we give communities autonomy in actually developing solutions that work best for them without putting the strings attached from our systems that doesn't allow for them to grow and own and build their capacity, not just politically, but in the community. And I found it interesting that this is a mainstream conversation now, because I've come from a place of marching in the streets with many of the folks that are here today, where when we spoke about community-led alternatives, it wasn't seen as something that was actually doable, right? It wasn't an evidence-based practice, but yet the folks that are actually in the system and have the most experience living it every day, trying to re-enter into their communities and better themselves, are not actually lifted up with the same level of expertise as our academic or legal evidence-based practices. So that's the first thing I think that we need to correct as we take an approach to change things, is that we don't have those answers. As institutions, as nonprofits, as agencies, we don't have the answers. If we did, we wouldn't see the racial disparities that were spoken to on the panel before this. We wouldn't see a disproportionality of Black youth being in King County prisons, youth prisons, at 51%, even though the numbers of youth that have been in the system went down. We wouldn't see that legal financial obligations are drowning people in debt at 12% interest, and actually taking that money from the assets of the community, from the families that are impacted by this. We wouldn't see that. And so what we need to think about when it comes to community-led alternatives is that we need to figure out a way to move out of the way. We need to, in King County, and maybe you guys are aware of this, there was a resolution passed actually in the city of Seattle for zero use of detention. That was an effort led by Ending the Prison Industrial Complex. Black and brown youth who realized that they needed to step to the city and King County Council and start to create alternatives to juvenile incarceration. That was at that same room that it got passed in just this year. 3 years ago, folks were being drugged out of that same room for saying the exact same thing. So we have a stigma, we have an implicit bias about what it means when communities step into their own self-determination. That is the first thing that we're going to have to step back on and start to fund community-led alternatives that are actually driven and owned by the community, not things that we co-opt and create and make a program of ours, right? Because we already know what happens when we get our fingers on things, but actually how do we get into a place of being supportive, responsive, and embracing what folks are asking for and starting to build themselves. A good example of this is Rainier Beach Restorative Justice Project. They have partnered with folks in Oakland who have had a really nationwide proven model of doing restorative justice through indigenous practices, indigenous African practices, practices. And they're piloting this in Rainier Beach. This is not a 501c3. This is not an agency. This is not supported by a foundation. These are community folks who went out and made that connection themselves and started to recreate and build the model. So I'll just leave us with 3 things that are happening. The folks behind me that are with Blackout Washington, can you stand up? These are the folks that are here not just because they're stories, they're here because they're experts in their own experience and they're working on solutions. Legal financial obligation reform is here and it's, a mainstream palatable thing, but these are the folks that brought that in since 2009, right? These are the folks that are fighting the youth jail in King County. And these are also the folks that are fighting for parole, which is not even a conversation we've had yet in Washington State and through an anti-racist lens. These are the solutions that are going to change our future. And I just want to honor those folks and you all, and I hope that we can make that connection after this to make some real change here.
Thank you for that. I have a quick question. So your basic suggestion is that we need to get out of the way and let the community deal with it. Does the community have the resources to be able to focus this as a resolution to a lot of the problem, or does it need support from the state? Yeah, that's a great question. So let me clarify. Our get out the way is sometimes when we, in our brilliance, have great ideas or we see an idea that's worked in other places, we'll attempt to implement that idea, right? And so what I'm saying is the implementation has to be left to the communities that are most impacted in building around that. The ways that we can support is through information, through resources, and making political space, which is what you're doing here today, which is why I appreciate it. But they do need to be resourced in that way. I think the thing that we've learned about the zero use of detention resolution in the city of Seattle, because there is a component to that that's supporting community-led alternatives, is that the implementation's where the things get lost, right? We've tried this before in our history with Seattle Youth Violence Prevention Initiative and also with Career Bridge. And what we've learned is that when the metrics of success are determined by the institution and not determined by the community, then we start to get into a place where we audit, question, push back, put more strings on, squeeze the life out of the good parts of the program or the effort that we see. So I think the get out the way is more, let's just recognize the impact that we have when we take a hold or take ownership of something. How do we partner in an accountable and respectful way with efforts that are already going on in the community? How do we not silo issues off into I just need these outcomes and I don't care. I care about LFOs and I don't care about parole or youth detention. These things are connected and people work on them in a connected way. So we have to think about how we fund, how we support implementation, how we determine measurements of success. And that's kind of what I mean when I say get out the way. It's our status quo. I have another follow-up question, but
Yes.
maybe we should do that offline. We can talk about offline. Let me throw it out there though. And this whole community-led alternatives resolution, does that also incorporate resources from the local police department for a more community-based policing system as opposed to a militaristic type of approach? So it's just something to think about.
We'll talk about that.
Okay, let me see. Larry Jefferson, please. Thank you.
Justice should not depend on the size of your wallet. Justice should not take advantage of people who are suffering from drug abuse. And justice should not be determined by the color of one's skin. I have been a frontline public defender for about 20 years, and I see disparity in the courtrooms every day, especially around the issues of economics, about how much money you have, about how much resources you have, about how much resources your family have. I've represented juveniles, and I came to my conclusion that I knew that juveniles could be successful based on the issue of bail, whether they got out or not. And so basically, in juvenile cases, you would have the opportunity for a case to be diverted. And so what the youth was supposed to do was to go to school and get letters from people at school or in the community or those types of things, or from anyone, and present that information to the court. Also, when they got out of court, the court could judge their behavior about how they acted when they got back into the community. So if your person could not get out to show those things, that means they were more susceptible to pleading guilty to offers where, oh, you only have to do 10 days. Oh, you only have to do 15 days. Or if you're a youth, a day in jail, that's incredible. And so the issue of whether someone got out or not determined. And so what we're dealing with is people who have lack of resources, that didn't have grandma who could watch them, 24 hours a day. And so where that came down was on my clients who were Black and brown and Latino, Native American, didn't have those resources because people had to go to work. So they stayed in jail and they got convictions. Whereas my European clients could get out because they had resources, they had grandma. Now, I'm not saying I didn't have Black clients who didn't have those resources, but that was few and far and in between. It's the same thing that's happening with my adult clients about whether, on issues of like first-time felonies, about whether they get out. I have cases where there are different types of diversion programs, okay? And so when the prosecutor gives out this diversion program, they're thinking, I'm letting this person off the hook. I am giving them an opportunity. Yet in Thurston County, where I practice, that diversion program is going to cost you $1,900, all right, to do the whole thing. And so you'll have people, so what I do as an attorney is I don't sign people up on that diversion program that I know that they can't succeed on. And I try to get them to reduce the charge to plead them to a misdemeanor, that I know that they can pay on the fine forever and it doesn't matter. But there are other attorneys who, with all these good intentions, get someone on a diversion, and that person doesn't even have a job, but they're taking it because it's an opportunity to get a felony off the record. Why wouldn't you take that opportunity? Boom, because they don't have the money, they wind up becoming a felon. Now, ways that we can look at our sentencing, looking at specific laws. I'm going to talk about DUI, like driving under the influence. We know that driving under the influence, very dangerous activity. I mean, very easy for someone to get hurt, killed, car accident, all those types of things. All right? However, if you get convicted of a DUI, that is a misdemeanor. All right? And I'm going to say that a lot of people in Bellevue or in those types of communities, I'm talking about European Americans, get DUIs. They get a chance at redemption by getting the conviction. It's not a felony. Yet, when people get convicted of methamphetamine, heroin, crack, it doesn't even matter the amount. We have convictions that are based on a baggie that the drug user who wants to take the drugs cannot use. But a scientist can come and say, there was a drug there, there was methamphetamine there, and that is the basis of a felony conviction. And you know what makes me the most upset is when I have my clients of color, they come in, they're expecting, they already know it's unfair. They already know it's unfair. But when I get a white parent who comes in for their white child, and they go, this is how the system works? It doesn't matter what I do from the time that I ran into the officer. It doesn't matter what steps, preventative steps that I've taken, that I'm still looking at a felony. With marijuana, we have an amount, over 40 grams. We could do the same thing with heroin, those things, and put in an amount requirement that says if you have over a certain amount, that's a felony, but under a certain amount, it's not. The last thing that I would like to say is about the issue of implicit bias. There's no one that I'm working with who is a judge or a prosecutor who is saying, I want to put a black person in jail today. There's no officer that I encounter that goes, I want to do this. But I took the implicit bias test Monday night. My implicit bias is a slight preference for European Americans. That's very embarrassing. Okay? Very embarrassing. But if I do not realize the bias, then I can't do anything about it. And I'll just say one more thing. In my practice, I realized many years ago that I was being biased towards people of Hispanic descent, that I was not listening to them, that I was not asking additional questions. And so I had to change my practice to where if the case was going to take an hour, For me, that minute was going to take 2, because it built in time for me to listen, because I knew that there were just cultural things that I'm not aware of that I need to take more time to listen to, and to make that space for, and to talk with people. So the last thing I want to say is garbage in, garbage out. We all pretend that that when you get a conviction, that it is all, and it is a felony, that it is all based on fairness. All my jurors know that the more money you have, the better attorney you have, you're going to get better justice. Yet we built a system that says if you go through it and you're a felon, that is a right finding. What we're doing by making people felons on an unjust system is we're saying we don't want you back. When I punished my kids, the punishment was to hang out with me so they could learn my values, okay? Because that's what I want them to do. The punishment should be that we want people to learn our values about what makes, America great, what makes Washington great. Those are the things that we want to instill. Thank you.
Thank you. I appreciate that. That's very wise, actually. I think that refers back to the community solution. And thank you for bearing your soul on your implicit bias test. I mean, you're leading by example. I think that we should give everybody here the challenge to let's take the test sometime within the next week. Okay? That's a commitment. All right. Well, thank you very much. Are there any questions for the panel? Thank you very much for sharing. I appreciate that. We appreciate that. The third panel is Professor Alexis Harris from the University of Washington Department of Sociology, and Nina Martinez of the Latino Civic Alliance. Please share your wisdom with us.
Great. Thank you so much for the opportunity to be here. I
Certainly.
appreciate it. I was actually told I had 10 minutes,
Oh.
so I can speed through.
Okay.
I'll go rather quickly. So for the past 8 years, I've been studying legal financial obligations in Washington State. I've looked at statistical data, and I've also done observations and interviews across 5 counties in Washington State. And so this presentation is based on that research that I've done. And just so sort of brief overview of what LFOs are, in Washington, we have a mandatory victim penalty assessment of $500 for people convicted of felony convictions, and a $100 DNA charge. That's mandatory. Everyone convicted of felonies receives $600, regardless as if they go to jail or prison. We also have optional costs that are viewed as discretionary. They can be court costs at $200, costs related to warrants, costs for your assigned counsel, your defense attorney. A regular charge is $450 in Pierce County. You have a fee if you opt to have a jury trial. You get a discount if you go for 6 at $125. If you want the full jury, it's $250. And then we also can be assessed incarceration costs. On top of that, there are fees. As you know, 12% interest begins accruing the day of sentencing, and we have a $100 annual collection surcharge that's also imposed. And then there are per payment fees on top of that. So, for example, Thurston County electronically, if you make payments, it's $5 to $10 per payment that you make. So these are the costs related to legal financial obligations. This is just an example of the Washington State Felony Judgment and Sentence Form, and you can see where all the costs are sort of added up. Essentially, people get a bill for being sentenced and processed through our criminal justice system. In addition to that, you can see that there are different counties prepare different types of bills for their defendants. I was even told by one prosecutor that essentially how it's managed is judges will make the sentence on the judgment and sentence form, and in some instances the county clerks will then prepare a cost of bill with additional costs. So essentially bills are being generated per conviction. And I need to note that yes, this works very differently in every county in Washington State, and there's a sort of this continuum of punishment. In some counties, there's the minimum $600 is assessed, and in other counties, the average is $2,200 per felony conviction. So there's a very different set of processes across the counties, our 39 counties. This is an example here based on 2010 to 2012 data of the amounts that the average amounts that are assessed. So in the past 3 years, Washington State Superior Courts have collected an average of 21% of the amount that they have sentenced to offenders. The average amounts of fines and fees, not restitution, that were ordered ranged from $177 to $238 across municipal courts. I'm not showing the municipal here, this is Superior. But the average ranged from $177 in 2012 to $238 in 2010. And you can see the actual percentage that are paid. Again, here's the example between 2010 and 2012, the average of cases per year was about 46,000. The average ordered amount was $995. The average amount paid was $207, so about 21%. So we are generating a great deal of money, about $10 million from Superior Court in 2010 to 2012. But that's based on a small number of payments for a large number of people. And if we really calculate the number of unpaid, there's a lot of debt that's just sitting out there over people's heads. And there's a great deal of consequences for this. If you can, this table here shows how the amounts accrue over time for individuals who are able to make minimum monthly payments, and that's usually ranges from $20 to $50 a month that the court clerks set people at. So here, for example, over 3 years, even if someone's making the $20 monthly payment, because of the interest and the collection costs, they're still going to owe $300, which is a significant amount of money. And it's important to note that in our Washington State Constitution, like many other constitutions, we have something that says excessive bail shall not be required, excessive fines imposed, nor cruel punishment inflicted. And this is actually counter to really what's happening on the ground level in our county courthouses. Again, it's important to note that this occurs in very different ways across counties. Some counties require regular court appearance for people who owe debt. Even if they're making regular payments, they're required to report to court every month. Some courts have specific LFO courts with monthly appearances. Others do not require appearances as long as minimum payments are received. Some send unpaid debt to collection agencies with additional fees. 17% add-on, can add on to the original principal. It's important to note much of this oversight and discretion is controlled not by elected people, but by non-elected county clerks. And so there's these different arms. Judges sentence, clerks manage. There's no oversight. There's no accountability to what's happening to individuals. And so there's a great deal of legal consequences. We have this protection in Bearden v. Georgia that says only willful non-payers will be incarcerated, but in fact, on the ground level, that willfulness, that discretion is being determined by conspicuous spending. I've seen judges ask defendants how much they've paid on their manicures, how much have they paid on their tattoos, how much do they pay on smoking cigarettes, and they say that's spending that you should have used towards your LFO payments, and therefore that's willful non-payment, and they're incarcerated. And this also, we talk about the financial consequences and the criminal justice consequences, but this leads to stunted lives and a great deal of emotional stress for people. There's strain on family and friendship networks. There's a negative impact on positive identity of self, and this runs completely counter to what the research says that we need to lead to desistance for criminal offending. We need to create positive opportunities for people after they're convicted and receive incarceration. So a large number of people are sentenced to monetary sanctions across Washington State. There's a great deal of variability. Justice matters by where you live, which I think is unfair and unethical. It generates a large amount of money, but also generates a large amount of debt and creates negative consequences for individuals. And so I'll just throw up my recommendations here quickly, that we need, sort of bottom line, there's a great deal of discretion that's happening with this process. The one thing based on my research that I found that we need to structure, if we're going to keep the sentencing practice, we need to just structure how that discretion is being allocated. We need clear definition on who is indigent. We need clear definitions on what willful non-payment means. We need a clear definition on ability to pay. Is it future ability to pay or is it current ability to pay? And what does that mean if someone's receiving state-assisted support, like Social Security or disability payments? So I think I did what I could in 5 minutes.
Thank you for being so concise. You did a great job of presenting. Any questions? I have a couple of real quick questions. First off, this whole concept of civil forfeitures, is that part of this LFO problem? I know it's a little different, but say you get your car impounded and you can't afford to get it out, and then all of a sudden somebody else owns your car, and now you can't get to work. Or I mean, it's got all these complicating factors.
Right.
Is that part of this bill?
It's not, no, it's not part of this bill from my understanding. It's part of the broader system of sort of this two-tiered system of justice, one for poor and one for those with means. And I didn't study that, but it definitely sort of highlights another avenue in which poor people are negatively impacted by contact with the criminal justice system.
Yeah, so one of the motives opposing the changing the civil forfeiture rules is that because it's a revenue generator. So I'm just wondering, is the entire argument against this LFO fix basically an unprincipled revenue issue as opposed to a principled issue around criminal justice? Or
So when doing the research and talking with the decision makers and some policymakers here, there's two levels of argument. One, it's about recouping expenses related to the criminal justice system and sort of in the name of victims. But part of the problem is that some counties collect that $100 annual surcharge but prior to reallocating payments to victims. And so this bill would address that, and it would truly prioritize victims in terms of receiving the restitution. I would also argue that if we eliminate all non-restitution based fines and fees, that would allow people who have been convicted to make payments of restitution and not sort of say, I'm overwhelmed and can't pay anything. So I think that would happen. Another argument is that this is a system of accountability for people who've broken the law, and they need to be held accountable. And what's lost in that argument is that the felony conviction, that incarceration, community service, community supervision, drug and alcohol assessment and treatment, that's all holding those offenders accountable. And that we don't need, in my mind, an additional monetary sanction that disproportionately impacts poor people and also people of color with the financial obligations.
Representative Ryu?
Yes, thank you very much. Can you tell me off the top of your head how much of the incarceration could be related to non-payment related court violations?
It's a really, really good question. I wish I knew. That's actually a reviewer in my book just asked me that question. There aren't data that allow us to analyze the percentage of people who are incarcerated related to non-payment. A lot of people are incarcerated for violation of the conditions of sentencing, and if you trace it back through their file, you can see it's related to non-payment of LFOs. I can't think of it off the top of my head, but the ACLU of Washington State did a report on Benton County and was able to analyze. And I don't want to give a number because that might be wrong, but there was a substantial percentage of what they were able to find of people in the county jail were there because of non-payment. We have policies in the state sitting out your fines and fees. So some courts will allow people to be credited up to $100 a day towards their LFOs if they sit that time out in jail, away from their kids, their family, their jobs, things like that.
Representative Rickdell?
Representative Ryu asked my question. Thank
Okay.
you.
Well, thank you so much.
Thank you.
I appreciate that insight. Ms. Martinez?
Thank you. Thank you, Senator Alzagawa and members of the Senate and House for inviting me. My name is Nina Martinez. I'm Chair of Latino Civic Alliance. We're a nonpartisan statewide advocacy group. I'm here today to talk about what do we know about police use of force. Nationally, how do we know it? And what should we do about it in Washington State? At present, we simply do not know how many times police in the United States use force upon citizens in any given year, much less the use of excessive force. Lack of data and research on the use of firearms by police officers in the United States, including Washington State, precludes sound understanding of the determinants of deadly force in police work. We learned more, to be honest, in the situation, as you all may have heard, of Mr. Antonio Zambrano Montes that was killed by police officers in Pasco, Washington. He was shot 17 times. And of course, this was alarming for anyone to be killed in our community in the state of Washington. And we also learned, became more aware as another Latino, Dan Covarrubias, who was shot and killed by police officers in April in Lakewood. And both of those cases, as you know, have been ruled justified. So the nature and scope of police in the United States, we know that approximately 18,000 state and local law enforcement agencies in the United States, about 75 federal non-military agencies exist. Washington State has approximately 260 agencies that employ over 11,000 police officers. And this is a generality approximate. Most state and local agencies are actually very small. And many of them actually have maybe 10 or less police officers in the United States. what we quickly learn is this, that reporting civilian deaths by police officers is not mandatory. And there is more data collected when a law enforcement officer is killed. And as we were doing our research, and concerned, if you Google or look, we found you can go to the National Law Enforcement Officer Memorial Fund, quite interesting. And it's a very savvy, detailed reporting collecting data mechanism. We know that, for an example, 111 officers were killed in the United States, 2 in Washington. We know their causes of death. We know whether they were shot by civilians, their age averages, the circumstances of the fatal shootings. Were they related to an auto crash? Were they related to the officer alcohol-related death? Was the officer using body armor? Was the officer, did he or she experience a heart attack? Were they killed by attempting to investigate a case? Which states were the deadliest for officers? And so this was alarming because as we were searching, we couldn't find that for civilian deaths by police officers. And so at that time, I was, imagine sitting across with the police chief of Pasco and asking questions and still feeling like there's not information I can, relate to or use as a resource. There is a few online because of what happened in nationals, like in Missouri and in cases throughout the United States. The Guardian is one. It's a media outlet. They have started collecting data, but it's not a concrete resource I think that we should be using. But they estimate 1,005 deaths in 2015. We estimate probably 20 to 30 here in Washington State. But just alone in Pasco, Washington, we had 4 civilians killed by police officers within the last 6 months. You compare that around the world, that's a lot per ratio. And we know that of the 1,000 deaths, at least 27%, and now what we know, okay, this is all of what the Guardian collected in the Washington Post, that 27% experienced mental health issues. Now, when we looked at The Guardian or any resource available, like for Mr. Antonio Zambrano Montes, his death, we know he was a Hispanic. We know he was from Pasco, Washington. When it says armed, it says other. Classification, gunshot. We know that the status ruled was justified. The brief analysis of talking about the case was police were responding to reports that Mr. Zambrano Montes was throwing rocks at a car. He hit 2 officers and refused to listen to commands, who tried unsuccessfully to taser him. Mr. Zambrano was running away from police with a rock and momentarily turned back and the officers fired. So it's pretty general. There's not a lot of information. We don't know whether Mr. Zambrano Montes was having any mental health or medical issues at the time. So historical backdrop to use of force data collection, what we learned. And I worked with Professor Matt Hickman with Seattle University. I highly recommend that you speak to him. And we know that the Justice Department, with the Clinton Crime Act in 1994, was supposed to enforce or was supposed to track the deaths of civilians by police officers, but it wasn't mandatory, and it has not been mandatory. And none of the U.S. Justice Attorney Generals have really enforced this. I'm hopeful that the current one today will. She seems to be enlightening, and I think my hope is that she will. But some of the common problems are all federal sponsored data collections are voluntary in nature. Private data collections tend to be less comprehensive, systematic. Definitions of force problematic, as well as variability in policies and procedures. So Washington State can and should be the nation's leader on the use of force data collection. Law enforcement agencies in Washington State should be required to report all use of force incidents. We recommend the Attorney General's office, but we would like it centralized by some agency to monitor this. The AG's office is already responsible for the homicide information tracking system, so we think that would be an area for you to look at and talk to them, please. The basis is the priorities is death in police custody, firearms discharge, or use of non-lethal. Whatever accounts for the relation between firearm violence and police shootings, additional research is needed of police using deadly force across our state. So solutions that we have. Establish a state database on police use of deadly force. The following information at a minimum is needed. That the number of incidents in which police officers discharge firearms at citizens, the demographic characteristics of the officers and citizens involved in each incident, the agencies and agents employing the involved officers and location of each incident, the particular weapon used by police officers and citizens, the injuries, if any, suffered by police officers and citizens. Most of all, not all police departments collect this information. We're seeing that the larger ones like Seattle does, but it's not shared. It's not easily accessible. So imagine the smaller police agencies. It's not happening.
Ms. Martinez, I'm going to have to ask you to wrap it up.
Okay, so I guess for us, the outcome would be is our recommendation is to create a state-based reporting data collecting mining tool and do it sooner than later if possible, because this will help us have dialogue, with the community and help with policy work. Without data, without information, it's really hard to have a really intelligent conversation with the police force or with policymakers. So we recommend that this be taken seriously.
Thank you. I was frankly shocked that it's not a mandatory requirement to report those incidents. Representative Moscoso.
Thank you, Mr. Chair. I want to thank Nina Martinez and the Latino Civic Alliance for the work you've been doing, and also to remind the audience that we did a work session in the House Public Safety Committee last year that I helped sponsor, dealing with fostering constructive relationships between police and the community. You can find the 2-hour video of that on TVW. There's a lot of material there that'll give you a good start on some of the information and data that we talked about here today. We are going to do a follow-up next year. We're still putting that together, so we invite anyone's contributions and ideas about how we can continue working on this issue. I also want to point out that Governor Inslee has called together a task force. We're working on a summit on racial equity. That's the working title right now for next spring sometime. So I do believe we're going to have a lot more conversation about this. I think this being our real first members of color public work session, I believe we are at the cusp of finally having the kind of dialogue and discussion we need to have in this state about these issues. So thank you both very much for your testimony.
Thank you.
Any other questions? I'd like to note that we've just been joined by 2 more senators. So if you wouldn't mind introducing yourselves, and thank you so much, Dr. Harris and Ms. Martinez. Appreciate your expertise.
Hi, I'm Jeannie Darnielle. I am a senator from the 27th District, which is the heart of Tacoma.
Senator Steve Conway from the 29th District, which is part of Tacoma, Lakewood, and also Spanaway. Thank you.
Thank you for joining us. Now I'd like to introduce Mr. Jim Bamberger, who is the Director of the Office of Civil Legal Aid, to talk
Thank you,
about
Senator.
disparities.
And thank you, members, for taking the time. You've been hearing a lot about the criminal justice and the juvenile justice systems. The Office of Civil Legal Aid funds resources that provide access to the civil justice system and, at some level, the child welfare system. There's no reason for me to duplicate what everybody else has said in terms of the structurally racialized systems that attach in every location. What I wanted to do was share with you the salient results of the most recent Civil Legal Needs Study update that we published on October 29th, which was the first look at civil legal aid, the problems that low-income people in Washington State experience since 2003. I'm going to fly through this real fast, focusing on the issues relevant to the work of the MOC. I want to make sure that you understand we engaged Washington State University Social and Economic Sciences Research Center to do the research for us. We targeted 126 census tracts across the state of Washington that were represented either by high poverty or high minority poverty. And you can see the plot not only of where those tracts are, but the participation that we got during the study of, and we had more than 1,600 respondents who participated in a 70-question, 138 legal problem study. One of the things that we can all remind ourselves is anytime we're talking about poverty, we're talking about race. every single racial group is grossly disproportionately represented in the ranks of the poor. And so one of the things that we know is that if you're African American, Native American, or Hispanic Latino, you have more than twice the rate of poverty than you have if you are white. One of the exciting things about the study and the penetration of our research is that we were able to get representative participation by every single census-based ethnic and racial minority group. The legal problems that directly affect low-income people direct their ability to access health care, secure shelter, protect their family physical and economic security and safety, and secure access to critically needed assistance. One of the things that we learned very, very early on in the research is who you are matters, and particularly what race you are. So if you're poor, and you are identify as white or Caucasian, across the x-axis you see the legal problems that we surveyed, and then up the y-axis you see the prevalence rate, the prevalence of problems experienced by members of these groups. So this is the trend if you're white. This is the trend if you identify as Asian American, and we did not disaggregate Asian American from South Asian, Pacific Islander, et cetera, et cetera. We just followed the census base. This is the trend if you identified as Hispanic Latino, and then the outliers. This is the trend if you identified as African American, and this is the trend if you identified as Native American. Very substantial racial and ethnic based overrepresentation and higher levels of prevalence. We also looked at discrimination and unfair treatment, first on the basis of race and the other legally protected categories. So again, if you're Asian American, the highest areas of discrimination were involved gender and age. Similarly, if you identified as white, then if you identify as Hispanic or Latino, you see national origin and race significantly higher than the average of the other two. And then if you're African American, 40% of African American respondents responded that they had experienced discrimination on the basis of race or color. And then we see compounding dynamics where we looked at age and disability, heightened levels in the area of age and disability. And then we also see if you're Native American across the spectrum, with the exception of sexual orientation, we see much, much higher levels of involvement in discrimination and unfair treatment. We also wanted to see, what impact big data has and whether it treats people similarly or whether it treats people differently. So we looked at two categories. One, we looked at prior juvenile and criminal system involvement, and two, we looked at discrimination and unfair treatment on the basis of credit history. And you can see in this chart that, again, if you were Native American, if you are African American, very substantially higher rates of improper treatment or discrimination on the basis of both those characteristics. The first one is not so surprising given the disproportionate involvement of people of those two racial and ethnic groups in the juvenile and criminal justice system. The second one raises grave concerns about what financial institutions and others and employers and housing providers are doing and using, and how they're using credit information as a ruse to treat people differently in access to these services. If you're a victim of domestic violence, across the spectrum, you have very much higher elevated legal problems and prevalence of legal problems. But then we kind of broke that one down too, and we looked at discrimination on behalf of experienced by victims of domestic violence and sexual assault, and we found that these folks were twice as likely to experience discrimination on the basis of race or color than the general low-income population across the entire spectrum of legally protected categories. Low-income people generally have very, very low trust and confidence in the civil justice system and the ability of that system to help people like them solve their problems. What I've not shown here is that there is a 10% differential when you look at it by white versus non-white. The trust and confidence in the system for people who identify as white as Caucasian is 10% higher than the trust and confidence in the system for people identified as persons of color. And we didn't disaggregate that, we just put all of the respondents of color in that. Perceptions, again, differ. If the question that we asked is, Do you believe people like you are treated fairly in the civil justice system? And so you can see here again, if you're a person of color, you have a much higher level of distrust than if you're a person who identifies as white or Caucasian. And if you're a person who's white or Caucasian, you have a much higher level of trust and confidence that you will be treated fairly most of the time or all of the time. The civil legal aid system, unfortunately, well, two things I'll tell you about the civil legal aid system. First, I will say that I'm pleased to report that we do not find racial differentials in the ability of people to access civil legal aid services. What we did find is that across the entire spectrum, 76% of the people who had legal problems don't get any legal help at all. And that's in large part because they don't know that the problem that they have is legal in nature. They don't know that there's access to services. And most particularly, the services that are available are unable to meet the need that they have. So, for example, the state of Washington, we have one state-funded civil legal aid attorney for every 11,000 people who live at or below 125% of poverty. 11,000. And we know 76% of those are going to have a legal problem a year. So it's a real challenge. We understand the responsibility and that the findings here, again, reflect the systemic dynamics that are race-based in our culture. And when you intersect the race with the poverty, it just compounds them. And then, of course, when you compound that with other considerations like disabilities, like age, like gender, then you see these systems operating to structurally remove people from the justice system, and ultimately the laws that you all pass here have no meaning for these people when they can't enforce them. Thank you so much for the work that you're doing, and I really look forward to continuing to engage in the conversation with all of you. Really pleased that the members of Color Caucus has taken a leadership role here. I've left materials for all of you,
Great.
so
I was
hopefully.
going to ask about that.
Yes, thank you.
Thank you. And for the previous presenters, anybody, we will accept written testimony. If you have something in paper you'd like us to review, we'll accept that and put it in the record for this meeting.